Hi, my name is David Gloria, and this is my Kinesiology 550 Legal Issues in Kinesiology Critical Assignment. I have chosen the athletic training facility / program as my subject matter, as I currently work as the sports medicine director at a small private high school in Southern California. The first topic we will discuss is risk management, and the first case we will discuss has to do with sexual harassment. In the state of Illinois versus Williams-Watson, Felicia Williams-Watson, a certified athletic trainer, was charged with 4 counts of criminal sexual assault and 2 counts of aggravated criminal sexual abuse. This took place at her place of employment at Massac County High School. Now, when we hear something of this magnitude, when we hear something this profound, how do we begin to mitigate something like this? And unfortunately, some cases like this are not always preventable. It was noted that Felicia Williams-Watson had every intent to pursue sexual relationships with 2 of the students at that high school. This was premeditated. This was not done by accident. So again, sometimes these tragic events are not always preventable, but what we can do as administrators, as directors, is begin to create effective training programs that emphasize knowledge, perception of sexual harassment, and standard reporting procedures. Sound harassment training within every athletic training education program. And what this does is it creates a safe environment for everyone who is working within our departments, from students, interns, to athletic trainers themselves. It creates a safe environment that, God forbid, someone in our department or program is a victim of sexual harassment, or they know someone who is a victim of sexual harassment, that they are comfortable, they recognize what's going on, and they are knowledgeable of what they need to do. That way, they will be able to come to us so that we would be able to handle these situations in an efficient and a professional manner. Next, we're going to talk about negligence. In the case Rios versus Grossmont Union High School District, a college student athletic trainer was called upon to oversee a high school football game in the state of California. During this game, there was an injury that occurred to an athlete. The athlete came to the sideline, was evaluated and treated and assessed by this college student athletic trainer, and then given the okay to play. Tragically, this same athlete re-injured himself, but this time it was a different injury, and it was a much more severe injury. He fractured a vertebrae in his cervical column of his spine. This required immediate transport and immediate surgery, which ended this young man's football playing days. The mother of this injured athlete brought a lawsuit up against the school, stating that the National Athletic Trainers Association states that this was negligence, that a college student intern should have never been able to assess and treat and oversee a football game. She also stated from the Commission on Accreditation of Athletic Training Education that students are to be under the supervision of a credentialed healthcare provider at all times when providing patient care, and that they not act as a replacement for appropriately credentialed staff. Now, this mother was right on, and she was right on track. Unfortunately, this happened in the state of California. And the state of California does not regulate the licensure of athletic trainers. And what this means is that anybody can call themselves an athletic trainer. Any high school administrator can hire anyone and give them the title of athletic trainer without certification, even without education. And so the school came back and said, we are not under the National Athletic Trainers Association because California doesn't regulate the licensure of athletic trainers. And unfortunately, this was true. And so the court sided with the school in a very unfortunate situation altogether. And so how do we mitigate this? What are some strategies here? Well, I would say as a director of sports medicine, administrators, please hire certified athletic trainers. Don't hire someone you know. Don't hire someone who has a little bit of knowledge in this. hire a certified athletic trainer. I would encourage administrators to know the standards of the Board of Certification. Review the Board of Certification so that you would know just how deep the complexities are of an athletic trainer. And if you can't afford an athletic trainer, I would at least hire an MD or a DO to supervise your games, and then you agree with what a reasonable fee would be. That's how I would begin to mitigate for this particular case. Next is communication liability. In the case of Searles versus trustees of St. Joseph College, Searles was a college freshman at St. Joe's. During the season, he complained of bilateral knee pain, in which he went to the athletic trainer for treatment and assessment. It was in the athletic trainer's best judgment that Searles take some time off for rehab and treatment. However, the courts found that this information was not effectively, professionally, or efficiently communicated to the basketball coach. So the basketball coach pressed Searles to continue to practice and continue to play, in which Searles did, which only worsened his conditions until the point where Searles had to quit, get surgery on both of his knees, which ultimately ended his basketball playing days. Now, the courts found that the athletic trainer and basketball coach were both liable and negligent in this case. And communication was the key word. Searles' condition was never documented, was never communicated in any way, shape, or form to the basketball coach, in which the basketball coach continued to press Searles to practice and play. The courts were in favor for Searles, and so what does this tell us? What does this tell me as an administrator or as a director of sports medicine? Is that there has to be a protocol, policies and procedures in place between coaches, athletic directors, and athletic trainers. Documentation is vital. Documentation is key. Communication is key. We need to communicate to avoid things of this nature, cases of this nature. And whatever the athletic trainer says, and whatever that is communicated to the head coach or to the coaching staff, that is what stands. So it's really just a case of communication, policies and procedures, following through with those policies and procedures to make sure something like this does not happen. Moving on to employment law, sex discrimination. Yakovich versus Mount Pleasant Area School District. Yakovich was an athletic trainer for 20 years at a high school. Before she was relieved of her duties as an athletic trainer, she kept her standing on the school board, however. And then she was hired with a private firm or corporation as an athletic trainer. During this time, the school that relieved her of her duty as an AT was considering hiring her back, but then found out that she had been hired with this firm. And there was a conflict of interest, according to the school and to the district, to have someone work for this private corporation, be a member of the school board, and work as an athletic trainer for the high school. So they rescinded and did not rehire her, only to find out a few short days later that the man that they hired to replace Yakovich at the high school, he was on the same school board that she was, and he also worked at the same firm that she had been hired to as an athletic trainer. Yakovich alleged of sex discrimination. Ultimately, the courts found cause for violations against discriminatory laws, and Yakovich was awarded a very hefty sum. Now, how do we mitigate something like this? And mitigation strategies here should be relatively uncomplicated as well. It's knowing the law. It's knowing the state regulations that are in place. It's knowing employment law. And if administrators don't know it, they should seek advice. They should seek counsel, or they should seek someone to explain it to them, so that if you're in charge of hiring and firing, or firing and hiring, that as you fire and as you hire, to know that you are not outside the scope of employment law. So it's really knowing the laws out there and the regulations that are out there and abiding by them. And if we don't know them, we need to ask someone for that legal counsel. Disability discrimination. In Kerr versus Drake University, Kerr was an athletic trainer who was fired after he was found urinating in an athletic training facility whirlpool. Now, he went to the athletic director and admitted that he had done this, but he did this because of an existing medical condition that, as a result, he had an enlarged prostate, which made him drink more fluids throughout the day, which made him urinate more frequently throughout the day. And while the athletic director was sympathetic to his medical condition, she noted and stated that Kerr never disclosed this information to her and that he had worked there for several years. But yet none of this information was disclosed to anyone. And so she terminated Kerr because of his actions. Kerr, on the other hand, sought that because of this disability, that he should have been given an exception because of his disability. Well, the courts sided with the school and the athletic director, and Kerr was terminated. Now, how do we mitigate something like this? Again, I just think it's common sense. We have to know the people who work for us. We need to know the people who we are interviewing. We need to know potential hirees, and we need to screen them professionally and diligently, so that if there is someone with a disability, that we can accommodate them. Accommodation requirements, reasonable accommodation put in place so that an employee with a discrimination can still perform their job with the standard that they are being held to. So that's how I would start mitigating that issue. And finally, age discrimination. In Moore versus University of Notre Dame, an offensive line coach, Moore, was fired from his job as a coach, and he claimed that the head coach gave the reason that he was too old. The head coach, however, said that it wasn't because he was too old, it was because he was not holding to the standards and expectations of the university. This went to the court as Moore alleged age discrimination, and ultimately Moore wanted to be reinstated. The courts did not give him that, but they did award him front pay as he transferred out of Notre Dame to his new job. And though university won in some sort of way, they also had to pay out money because of this case. And so how do we mitigate something like this? And in business necessity defense. And this has to do everything with job requirement connected to job performance. And to make sure that we're covered in any sort of area that would bring about age discrimination, we have to make sure that if there's a requirement for a certain job, that individual can perform that requirement because that relates to his job performance. And if an individual cannot perform that requirement, and we choose not to hire them, it's not because they're too old, it's not because they're too young, it's because of the business necessity defense that we have put in place. This will protect us from any such case such as this. Future career plans. Well, I think it has everything to do with what I just said. It's about preparation, it's about knowing in advance, it's about understanding the laws, it's about creating safe environments for those who work within our department, and it's taking all of this information and really sorting through it to have a very credible place of business. And so my future career plans definitely entail these things 100%. And as I continue in my career, I will continue to unpack these things to make the best possible working environment for myself and those who work within our department. My faith integration starts with John 13:14-15. And since I, your Lord and teacher, have washed your feet, you ought to wash each other's feet. I have given you an example to follow. Do as I have done to you. Romans 12:18. If it is possible, as far as it depends on you, live at peace with everyone. And 1 Peter 2:13-14. For the Lord's sake, submit to all human authority, whether the king as head of state or the officials he has appointed. The first verse talks about servant leadership. I want to serve as a leader, bend the knee, and serve those with me, below me, and above me. I want to work and be at peace with all those that I work with. So it is up to me as a Christ follower to pursue that peace, to have a healthy working relationship. And finally, submitting to all human authority. We need to follow the laws. We need to follow what is out there. And it's for our health, it's for our wellness, but it's also for the health and wellness of all those that we work with. That is my assignment. Thank you, and God bless.